بسم الله الرحمن الرحيم. الحمد لله رب العالمين، والصلاة والسلام على أشرف المرسلين. أما بعد، يسعدني أن أرحب بكم الزملاء والزميلات أمناء الإفلاس والخبراء والممارسين في الإفلاس بشكل عام في ورشة العمل لهذا اليوم، والتي سوف تتناول بمشيئة الله التجارب الدولية في الحلول العملية لمعالجة التحديات الناشئة عن استمرارية الأعمال والتصفية، وكذلك بيع الأصول. هذا البرنامج حقيقة يأتي ضمن برامج التعليم المستمر للأمناء والخبراء، ويستمر لمدة ساعة ونصف بمشيئة الله. سعداء بوجودكم معنا. أود التنبيه إلى أنه تتوفر خدمة الترجمة بالعربية عن طريق الضغط على زر اللغة في الأسفل. يمكنكم الضغط على زر interpretation، ومن خلاله يمكنكم الاستماع إلى الترجمة باللغة العربية. مرة أخرى أود أن أنبه إلى أنه يمكن الاستماع إلى الترجمة باللغة العربية عن طريق الضغط على زر اللغة في الأسفل واختيار اللغة العربية. اسمحوا لي أن أنتقل للحديث باللغة الإنجليزية الآن لأرحب بكم أيضا من جديد، وأرحب بالمتحدثين لهذا اليوم. So, good afternoon, everybody. On behalf of the Bankruptcy Commission, I'd like to welcome you all to the online workshop on practical solutions to resolving challenges arising in bankruptcy, going concern, and liquidation sales. This workshop is part of Bankruptcy Commission Continuous Education Program, which aims to raise the level and quality of practice in the bankruptcy field by including every relevant party, especially the licensed trustees and experts. Actually, we are honored to have such a distinguished panel of experts with us today. Each of them has a wealth of experience in this subject. We know that our audiences have a wide range of questions and concerns, and the panel today will shed light on some of the international practices on the way to tackle practical solutions. Before we begin, I'd like to take a moment to thank our panel today. So thank you for your willingness to share your expertise with us, and we appreciate your time and taking the time to be here today. I would like also to thank our partners, INSOL International, CLDB, and the World Bank Group. Without them, this workshop would not be possible. So thank you so much. And now, without any further delays, I'd like to introduce the panel chair for today's workshop, Mr. Andre Martinez. Mr. Martinez is a senior financial sector specialist with the World Bank Group's Finance, Competitiveness, and Innovation Global Practice. He has been a lawyer for more than 20 years. He has a magister in corporate law and specializes in the area of insolvency and creditors' rights. Mr. Martinez is no stranger. He is no stranger to the Saudi bankruptcy law. He participated in the early stages of the development of the Saudi law. He has also spoken on several occasions to audiences here in Saudi Arabia, including the first conference on bankruptcy held in April 2019, I think, here in Riyadh. So, Mr. Martinez, the floor is yours. Thank you so much.
Thanks, Mr. Abdullah. It is fantastic to be here again in Riyadh, even though virtually this time. I want to echo my thanks to our partners, beginning by the Bankruptcy Commission. As Mr. Abdullah mentioned, I was very lucky to be in Riyadh many times, including when the Bankruptcy Commission was formed. So at the very beginning of the process, and it's absolutely phenomenal to see how much work it's been doing in these last couple of years in strengthening the insolvency profession in Saudi Arabia. So it's always a big pleasure for me, and obviously for the World Bank, to continue to partner with the Bankruptcy Commission in Saudi Arabia. The same, of course, with our good friends from Insul International, from CLDP. We've done many things together around the world, and these capacity building events, these trainings, these discussions, right, are extremely helpful for not only for particularly for us. It's very enriching to listen to you as practitioners in the audience, and to try to have a conversation about how to improve the bankruptcy system in the kingdom. So that's we're very lucky to be able to partner with CLDP and with Insul International. This new webinar is about liquidation, is about going concern sales, it's about intangible property. We're talking about basically a lot of different aspects of asset sales. We were specifically asked to focus on practical solutions to resolving these challenges from bankruptcy going concern and liquidation sales. One of the topics that was specifically asked by the Bankruptcy Commission is to also look at valuation aspects. So that we were asked to do from not only so basically from the perspectives of the UK and the US, and that's what the panel today is going to be about best ways to maximize value, to sell assets, and particularly to try to sell businesses as well. So that's kind of the big picture, and I'm extremely lucky to be joined by a absolutely fabulous panel, who I'm going to introduce now. So we have Paul Zalkin, who's I'm just going to say the titles, by the way. I trust everyone, all the participants have access to their full bios. So Paul Zalkin is a managing director in the restructuring and insolvency practice at Quantuma in the UK. Patrick Potter, whom I'm sure many of you know already, he's a partner in the insolvency and restructuring practice at Pillsbury, Winthrop Shaw and Pittman in Washington, D.C. He's clearly no stranger to the bankruptcy system in Saudi Arabia. He also sits at the organizing committee of a conference that is going to take place in Riyadh in January, that is organized by Insul International. He probably is going to talk more about it. Susie is going to talk more about it later as well. So, and it's important that you also keep this in mind. Then we have Duncan, and I apologize for pronunciation, is Einskov, I hope. And Duncan, you will correct me later if I mispronounce your name, who is the managing director in the commercial and industrial division at Gordon Brothers in Europe. And last but not least, we have Mark Bilbao. And Mark, I'm sorry, but just give me 1 second. For some reason, I don't have your bio handy. I'm so sorry about this. Who is a senior managing director and co-leader of FTI, West Region corporate finance and restructuring practice. Mark is based in Los Angeles. So this is the panel that will join me today. And let me start and kick off with some questions for the speakers. So I think Paul, we will start with you. My first question is, we've been discussing a lot about going concern sales and individual liquidations. Sometimes liquidations of assets are easier, more traditional. The question is, are going concern sales always preferable? And is there any requirement of types of companies to do going concern sales? And what are the key success factors that insolvency administrators need to take into account depending on the nature of the case? So Paul, the floor is yours.
Thanks very much, Andres. And thank you very much to everybody for inviting me onto this webinar. I'm very grateful for the opportunity to talk to you all. So the question is, are going concern sales always preferable? And the sort of first point to make is, well, it sort of depends upon the situation. generally, what I would say is that if the circumstances allow, and if the assets that are being sold form part of a trading business, and it's going to be possible to keep that trade alive, but subject, of course, to successfully restructuring the business and being able to manage and work through creditor pressure and the issues that have given rise to sort of the failure and have given rise to insolvency. But if you can manage all of that, then generally speaking, you are going to sell the assets for greater value on a going concern basis than if you broke the assets up. But of course, it's very, very specific to the circumstances. And I'll come on to this sort of critical success factors in a second. Now, what I've just said doesn't necessarily apply to all assets, of course. So if you were to take something like a fleet of delivery trucks, in many respects, and I'm sure Duncan will sort of correct me or add to this if he believes I'm wrong, but a fleet of delivery trucks will have, to a greater or lesser degree, a commodity market price. And it won't necessarily, the value that somebody will pay for those trucks won't necessarily change or be dramatically different whether or not you sell them as part of an overall package of assets in a business or you sell them individually. You know, a truck is worth what it's worth in the open market. But if you were to take a production line in a factory, it's inevitably going to be worth a lot more if you sell it where it is without having to dismantle it and remove it, and you sell it as a working asset. That's going to be a lot more valuable than if you had to sort of break that production line up, because the cost of removal, the cost of decommissioning, the cost of recommissioning, all will impact what somebody is willing to pay. So generally speaking, yes, it's better to sell assets on a going concern basis. That will apply to the majority of assets, and it will apply in circumstances where there is a trade associated with those assets. Now, it's worth specifically talking about real estate as well, because we have real estate that could be associated with a business. So you could have real estate associated with a restaurant, a hotel, any number of different types of real estate, which we will call sort of goodwill real estate. That's going to be different from just, say, selling a development that is part built, where there isn't a trade associated with it. So real estate is almost a completely sort of separate topic and a completely separate discussion. But if you have, let's take the example of a hotel. The value of the hotel as a building is going to be a function of the revenue and the profits that that building can generate for the owner. So if you sell a hotel, you will get more for it if you sell it alongside the trade of the hotel than you would if the trade of the hotel had ceased and all you're left with is the bricks and the mortar, the fabric of the building, which would then have to be repurposed in some way, or a new trade would have to be developed there. So real estate is as I said, a separate topic, but similar principles apply. Now, coming on to critical success factors. Generally speaking, if you want to sell an asset on a going concern basis alongside the trade of a business, one of the key factors is, do you have the time available to do it, given you might have very significant pressure from creditors who, certainly in the UK, different classes of creditor are able to use different types of process, and those things sometimes conflict. One creditor might seek to put a company through a court-driven liquidation process, which is not as good as using one of our sort of rescue insolvency processes. So do you have the time in order to sort of keep creditor pressure under control in order to deliver a better outcome and an enhanced going concern sale? Question number one. Secondly, do you have the liquidity available in order to keep the critical functions of the business going whilst you are trying to sell it as a going concern? Because you need to be able to continue to pay payroll, critical suppliers, etc., raw materials. So do you have the liquidity during the course of the restructuring process? Regulatory permissions can sometimes be an issue. Sometimes there are certain types of asset that require some sort of regulatory permission. Again, an example in the UK, if you transfer a fleet of commercial vehicles, we have something called an O license, an operating license. And there's a process to make sure that when you transfer those vehicles alongside a business, does the new owner have an operating license? So there could be regulatory issues. And then perhaps one of the absolutely key factors is, are the staff of the business and the key staff willing to support the process? Because you can't sell a business and its assets on a going concern basis if you don't have the staff there to operate that business. And then my very final point is there has to be demand for the assets on offer. They have to be attractive to the market. There has to be a market for them. So I think that's a bit of a quick summary, but hopefully that sort of answers some of your questions, Andres.
Thanks, Paul. That's fantastic. I think I took note of quite a few of these key success factors in the UK to try to stimulate more going concern sales. I wonder. Let me pass it on to Patrick. Patrick, I wonder if similar concepts apply in the US. What about the tools to generate these going concern sales, and what are the key success factors also in the US to sell and maximize value in going concern sales?
Thank you, Andres. Good morning, everyone. Salam alaikum. It's great to be with you all again. It seems like just yesterday that we were doing one of these, and I was recently in Riyadh. We're time constrained. Time management requires me to move forward, but I can't tell you how pleased I am to be back with you again. And I look forward to seeing you in person in January, and we'll talk more about that later. Briefly, I'm going to talk about quickly three things in the U.S. system. I'm a U.S. lawyer. One thing I love about this panel, I love what Paul just said. I'm going to love what I haven't even heard it yet, what Mark and others are going to say, Duncan, because they're not the lawyers driving, they're the business people driving these decisions. And the lawyers are important, the legal framework is important, but the business people are much more important than the lawyers. And so I'm going to try to help shift as much of the time today to the business folks. You've heard me speak before, you'll hear me speak again. I'm going to talk about three ingredients in the US system that I think, from my perspective and through my lens, quickly are important to the success of going concern. There are others. The first is speed and certainty. The second is the sale order. And the third is that we have a culture that we don't let creditors and non-debtor stakeholders engage in tactics that slow down and hold up a sale process. Taking them in that order, speed and certainty. In the US, we've been doing going concern sales for decades. Whether it's in a liquidation, which usually isn't, but can be, but more often it's in a controlled situation in a Chapter 11 rehabilitation, reorganization process. The steps are almost, as I say, cookie cutter. The first thing that'll happen, maybe even before the bankruptcy, is that someone like me, a lawyer, will sit down with someone like Paul or Mark and someone in the marketing who actually knows the assets that are being or the business of being offered for sale. And we'll map out the best process. Maybe we'll have a pre-selected buyer, we call it a stalking horse. Sometimes we won't. And we will map out a process for marketing the sale, and marketing the asset, marketing the sale, and we will go before the judge and get approval of the procedures. Step number one, the procedures for undertaking an effort to market and sell the assets. The judge, there may be some tweaking, some negotiating, but ultimately those procedures will be approved by the bankruptcy judge. And then the parties will be off to the seller, the debtor will be off to the races with the insolvency professionals and with the marketing folks. A data room will be open. Potential bidders will sign confidentiality agreements. Hopefully, if you're the debtor trying to sell, there'll be multiple bids. There'll be a bid deadline, and then hopefully a robust auction will take place. In most cases, right after the auction, the highest and best, and I believe Mark will talk more about the concept of highest and best, but the highest and best bidder will be taken before the bankruptcy judge. The bankruptcy judge almost always will approve the successful bidder, and then the transaction, for reasons we don't have time to get into, will almost always close immediately after the sale, meaning the next day or within the next few days. So number one, speed and certainty in the process. Others will talk more about why that's really important, but I think that's key. Whether it's first or second, number two, in terms of priority, the sale order. The sale order is the golden goose, the gem of the sale process for the buyer, because what it really does is it gives what we call free and clear status to that which is being purchased by the buyer, and allows the buyer to sleep at night and never have to worry about whether any of the creditors of the seller, of the debtor, can ever come after the buyer. There will be no form of successor liability. All the liabilities, except those expressly agreed to by the buyer, will remain at the bankruptcy level, and the assets will come out of bankruptcy, the business will come out of bankruptcy, and the buyer will be able to move on with life. Very important. Sale order, critical. Without it, process doesn't work. Third, and the sale order will be honored by other courts as well. So without it, again, it doesn't work. Third, we don't let creditors engage in extortionist type tactics in order to try to get better, sweeter deals because of their one-off situations. For example, secured creditor cannot hold up a sale process. A secured creditor has credit bid rights, and can, if it doesn't like the result of the auction, can credit bid. If the auction results pay them in full, then they'll be paid in full. If it's a short sale, then they can outbid if they want to take over the secured creditor wants to take over the asset. Ditto with unsecured creditors, except they don't have a credit bid right, and rarely do you see unsecured creditors actually bidding. But for creditors complaining about the process, the judge often says, "You don't like the process? Then go out and find a better buyer, a higher buyer." Sale proceeds, next point. Sale proceeds are paid in accordance with the priorities of the creditor hierarchy, and where there are disputes in that respect, then you put the money in escrow. Let the judge figure out the disputes later. Don't hold up the sale. Put the proceeds into escrow. Let the parties fight about it later. We're not going to hold it up. Sometimes regulatory, as Paul mentioned, sometimes regulatory authorities get into the mix. Usually it's to monitor the process. They threaten to hold it up, particularly in areas of environmental and other. At the end of the day, governments want businesses to survive, and regulatory authorities rarely hold up bankruptcy sales. Finally, anti-assignment provisions in contracts are typically void or otherwise sort of blown out. They're not honored in bankruptcy. So a contract says the counterparty can prevent the debtor from assigning a typical contract as a part of a sale. The bankruptcy court will not honor those kinds of provisions. Typically what the debtor has to do, what the seller has to do, is cure financial defaults and then show proof that the buyer can honor the terms of the contract on a go-forward basis. And notwithstanding anything else in a general contract, there may be some exceptions, but as a general proposition, despite what the contract says, it will be able to be assigned as a part of the going concern sale. There are several other provisions that make bankruptcy sales attractive in the United States, but I'm going to stop there, Andres.
Thanks, Patrick. That was an excellent summary. I think there's a lot here to absorb, and a lot to continue the discussion. Let's switch to Mark. I think, as Patrick was saying, also looking at it from the business side, and I know you've been representing companies and creditors in all phases of workouts, restructurings, and 363 sales, which is something rather unique of the US, right? So I would like to hear from you, first of all, if you have anything to add with regards to the distinction between going concern and asset sales, but also about a little bit more about the complexities of the US 363 sale processes.
Sure. Hopefully everybody can hear me. Again, I thank everybody for allowing me the time to speak to you, like the rest of the panelists. So I look forward to this discussion. I think from my perspective within the US process, I'll touch on various concepts that Paul mentioned and Patrick mentioned as we go through a going concern sale in the 363 process. But as Paul mentioned, as you manage an asset sale and a going concern sale, a line, for example, in a factory where you're trying to sell a line, the underlying issues there are really, how do you manage the people involved with producing the product? Whether those people are customers, their vendors, their employees, their management, you've got to make sure that those people are continuing to be incentivized to help you maximize the value of that asset. In this circumstance, the line inside of a production facility. So I think an important piece is the human element to this whole going concern sale, and really managing the intangibles and getting people comfort that at the end of this probably long and stressful process for the employees, customers, vendors, that there is a better home for this asset going forward, and that you're preserving jobs and things like that. So I think communications are extremely important. As Patrick mentioned, when we first get involved, and I'm involved with 3 of them now, we sit down with counsel and we figure out the best marketing process. Has there been any marketing done before you file? How long do you have during the pendency of the bankruptcy to market the asset? We have something, and Patrick touched on this, something called the automatic stay here, which basically keeps creditors, both secured and unsecured creditors, at bay as the debtor and his professionals tries to market the asset and create the most value in the marketplace for the asset on a going concern basis. So we come to that piece of the automatic stay. Also, within the US, we typically have arguably enough time, whether that's 90, 120, 180 days, to market the asset on a going concern basis. So that involves a whole process of identifying bidders, both strategic and financial. And typically, a lot of strategic bidders have some interest in these assets, and that's what you're going for, because a strategic bidder is typically going to provide the most value versus a financial bidder, because it can fold this asset into some form or some part of its business. So they have a reason to pay more than just a financial party looking at the cash flows of the business, because there's built-in synergies for a strategic bidder as compared to a financial bidder for the most part. So I think from a time perspective, we have time to market the asset and keep the creditors at bay. As part of that process, though, and I think this is an important piece, each creditor group, whether it's a secured creditor or an unsecured creditors committee, has a say, has input in marketing the assets, has input in how Patrick describes the process and the motions that have to be filed, whether it's a bidding procedure motion or a sale motion. You have all of the constituents who are beneficiaries of this process will have input into the process and how it's managed. Now, sometimes there's not an agreement on some of that, but you try and forge an agreement, a consensus among a large group, which typically is not easy. Everybody has a different agenda, but you forge an agreement, and if you can't, you take it to the judge, and the judge forces an agreement on process and how you move forward. So I think from a US perspective, clearly we have a consensual process we try to come up with in managing going concern value. And I think it's important to have a consensual process, because if you don't, since it's in court and it's public, everybody sees it, and that typically detracts from value if we're all fighting as to how to move forward and basically manage the going concern sale. The last piece I will touch on here is highest and best. And I think Patrick mentioned this. And in the US, we have a concept of highest and best value. And sometimes the highest value is not the best value. I mean, the judge takes all factors into consideration in determining what's best value. If somebody's going to pay $1 more, but lay off 400 people as part of that $1 more, they're going to consider that as part of the overall value that some bidder would bring to the process. So I think it's a holistic view on what a bidder brings to this process. And sometimes it's not necessarily the highest value, it's the best value when considering all of these concepts. So with that, I'll turn it back to you, Andres.
Thanks, Mark. Can I follow up very quickly on the last thing you said? I mean, how is that best value determined? Is that the bankruptcy court that determines that the best value? I mean, can there be challenges about that? I mean, the case you put, it was clear, right? So $1 more versus firing 400 people, it's such a clear case. But I mean, I imagine that in greater cases, there may be some disputes around that. So can you clarify how to determine that best value?
There is, and the debtor will determine in consultation with the other constituents what they think the best value is, and hopefully they can drive a consensus as to why. They'll go talk to the secured creditor, they'll go talk to the unsecured creditors committee, and the whole idea is you're working among that small group to come up with what collectively you think the best value is. Clearly, there's some disputes, and if you have those disputes, you'll take them to the judge.
That's excellent. Thank you, Mark. That was very enlightening. And I'm sure that these topics will come back, particularly in the Q&A. And I want to just, before I pass it on to Duncan, I want to stop for 1 second and encourage all participants to please write your questions in the Q&A box. So we left quite a bit of room for questions and answers today. I want to emphasize, as Abdullah said at the beginning, please start writing your questions now, and we'll cover all of them at the end. If you have questions for any of the speakers individually or general questions about the practice. Moving on to you, Duncan. I mean, I think, I mean, I was in the previous discussion. I mean, you have 30 years of experience in the industrial auction and asset management industry, and Gordon Brothers is obviously a major player. It's been mentioned a few times, but how important valuation of assets is. And could you share some views, please, about the techniques for valuation and the institutional capacity required for successfully evaluating both assets and companies? Let me pass it on to you, Duncan.
Sure, thank you, and also thank you very much for inviting me to speak on this panel. I've been watching the attendees, and also the Q&A is pretty active, actually, Andres. So I'm sure there's going to be some questions at the end as well. So yeah, no, a good deal of experience in this field in many jurisdictions. So I think we're probably going to concentrate just on UK and US as we discuss, but I think a lot of the valuation principles will be common worldwide. You know, importantly, we act as a third party, independent party to value assets, okay? And we're often employed by the bankruptcy lawyer, the trustee, the administrator in terms of the UK to provide that third party valuation. But when you look at the business, you know, the business that's in trouble, we wouldn't typically do a business valuation. That's really an accountant's job, and in terms of, you know, a business, what's its turnover, what's its earning multiples, etc. But in the point of real distress, and they want to know what the liquidation value of the assets, then that's when they turn to us. We're typically asked to look at across the balance sheet in terms of the categories of assets, and each has its own sort of peculiarities, really. So if you look at, for example, intangible assets, brand, goodwill, intellectual property, though, these sort of things have their own specific skill set, and I guess what I'm saying is not all values are equal. Some firms specialize, and you need to be careful about the competencies of these companies as well, because valuing goodwill, valuing IP, valuing a brand, particularly if it's something like a retail brand, obviously there's a great deal of work that can could be done to come up with that value, and that is sort of a lot of work and a very deep dive on sales, revenue, licensing products, etc. So you've got to really think about what assets are you asking someone to value? If we come back to the more traditional assets, your plant and machinery, we've already discussed, you know, a production line in a facility, inventory, the goods, either raw materials or even finished products can be asked to value. And of course, we've touched on real estate and vehicles, which Paul did at the top as well, which is sort of their own categories. So as I say, you've got to really think about when you're looking at and you've been asked to do a valuation, you've got to remember that we're doing this for a third party. We are going to be providing this and it's going to be used by that third party in outcome statements or to go before a judge. So it is an independent valuation. And we're typically asked to look at what's the value of these fixed assets in situ, as in the line, or ex situ, so if it's going to be removed. And then we'll also have to opine on the strategy. So it's all right saying something is worth X amount if it's to be removed. But if you can't define that sale period and somebody says we've only got 30 days, then that value can change as well. So typically we will look at the value based on its in situ and then its ex situ given certain circumstances. And that may be we need 180 days, 90 days to recover that value. But when we've taken the standard we're looking at and the methodology of it, we look at typically what's the market evidence. Okay, so whether it's a vehicle, whether it's a machine tool, what are they selling for? It's a very, very opaque industry sometimes in some of these machine tools, metalworking, and you can't really, but there is a lot of public data. And we also we as a company, we follow all the sales, anything that's public and online, we track that. So we have a good starting point for evaluation, and that starting point is what's it selling for in the market, wherever it is. This used equipment is sold and traded globally. So we look at what it's selling for, find some comparables. If you have a question, you need to look at where did we find this information? When was that trade done? So find what it's sold for. Now, of course, that's not always available. For things like vehicles, it's much more public available, and that's you can find that very easily. But if you haven't got that sort of information, then you need to look at and do some research, and you need to look and maybe even speak to traders, speak to brokers, find out what they think about it. Is this the right model? That model's not popular here anymore. It's got the wrong engine. This can be very crucial in an evaluation of vehicles. It's not got the right, you can't use them in London anymore because they're not compliant. Okay, I can give you specific examples, and clearly this is my favorite subject, Andres, so please don't let me run over time. But where a vehicle is a fleet of big transport logistics trucks were not compatible with Europe because the engines were Euro 4, which is a standard in terms of their emissions, but they were too clean to be sold into Africa because they won't work on the fuel down there. So there's lots of things you've got to take into consideration when you're coming up with values, comparable evidence, what the trader's saying, what the dealers are saying. If that isn't available, then you have to go back to cost. What was it new? Take that and look at some depreciation. So typically, depreciation principles are defined by the RICS, which is what we report under. So you take on those depreciation principles and do some calculations. But often all three are. So you can mold it into a realistic in situ value for these assets, but then also a restricted time to remove these assets from the premises. And so we try, as a valuation business, as valuers, we will try and give you all those options. So if you do get somebody that comes along and says, I'm going to save those 400 jobs, but I'm going to pay you this for the machine, at least you have a benchmark. You can say, well, the third party in situ value of this line is X, but then you can factor that into the discussion, because the worst case is it has to be sold ex situ and dismantled, removed, and all that costs and all that uncertainty, which obviously is a different number. So the in situ and ex situ market values can help the process of the going concern sale, if that's what it's going to be. So I think it's really, really important to sort of look across the balance sheet, look at the assets you're wanting a value for, and then consider, the third-party valuation on both bases, in situ, going concern, and removal. But also, what is the exit strategy, and we'll report on what is our options here. If this business rescue or this sale doesn't happen, what is our worst case scenario, which is the liquidation sale, which is the breakup sale. So, you know, there's lots and lots of things to consider when arriving at your valuation figure. But for the professionals that we're advising, we'd like to give them as much information with as much data, as much background, as much research into values to help them make their decisions. So I think, sorry, so you know, I'm not. I can ask more questions, but I think the principles are hopefully I've got across there in terms of what a valuation. If you're looking for a valuation of business assets, you know, some of the drivers of that.
Absolutely. I think that was super clear. Thank you so much, Duncan. I think, and I'm sure that if, given how active the Q&A box is, I can see questions coming up. It's already at the 11, so I'm very glad that we left a big buffer for responding to them at the end. So let's move on to I mean, you mentioned intangibles at the beginning, Duncan, and I was wondering if there are any provisions in the different statutes that deal with intangibles. So Patrick, let me turn it over to you. I was wondering, in the US, do you have any specific provisions that dealing with the around intellectual property and intangibles in general?
Yeah, not necessarily intangibles in general. There have been a number mentioned during this seminar so far: goodwill, brand, sort of going concern value. I think meaning the delta or difference between the going concern and liquidation, which was the subject of a very heated discussion at the III conference in Amsterdam earlier this year. But I'll focus, given the time limitations, and I want to be quick, on intellectual property, and primarily focus on copyright and patents, and less so trademarks. And there are really two scenarios, right? One where the debtor, the seller, is the licensee of the intellectual property, and part of a going concern sale that Paul and Mark are talking about, you know, the buyer needs that intellectual property as a part of the business. And the alternative is where the debtor is not the licensee, but the owner of the intellectual property, and what to do with that intellectual property on a go-forward basis. And I'll go through each of them in turn. So first, where the debtor is the licensee, things can be theoretically a little tricky here, because the United States has an entire body of intellectual property law that is not unlike, say, contract law under state contract law, which is largely displaced by the federal bankruptcy code. Federal intellectual property law is not largely displaced by federal bankruptcy law. So there are situations theoretically, and sometimes I've seen it, but rarely practically, where the debtor seller is the licensee of the intellectual property, and the licensor, who's not in bankruptcy, has some powerful rights under intellectual property law, and theoretically can come in and install and hold up the process, contrary to the many examples I gave a few minutes ago. But it's because you got two competing federal bodies of law here, the intellectual property laws. That rarely happens, though, I think, as a practical matter, because the licensor licenses intellectual property for a reason, and that's to derive revenue from the licensing, for the royalties. And so as a consequence, unless it's a really unique kind of intellectual property, if it's very fungible, licensed, to hundreds, thousands, tens of thousands, then there's really nothing unique about it. And so long as the debtor seller cures any defaults, financial defaults under the license, and the licensee, the buyer, the transferee, agrees and has the ability to comply with the terms on the license on a go-forward basis, rarely do you see disputes around the transfer of a debtor licensee's right to transfer the intellectual property license to the buyer as a part of a going concern. The second situation is where the debtor is the owner of the intellectual property and licenses the intellectual property to a non-debtor party. And here, there were some significant lobbying efforts into the bankruptcy code, in our bankruptcy statute, to protect licensees, particularly in the context where the debtor licensor is not going to honor the license going forward. Intellectual property, and I'm not an intellectual property lawyer, but intellectual property agreements often, if not always, will have requirements for the licensor to do updates and upgrades and so forth and so on, which may be costly and affect its overall, business structure, and may be related to or not related to necessarily the downfall or the financial stress put on the licensor. So we've got the specific provisions in the bankruptcy code, whereby if the parties, if the licensor is going to honor the agreement, then you've got no issues, right? The bankrupt party is going to continue with the upgrades, and the licensee will continue. Non-debtor licensee will be able to continue to use intellectual property. The problem is when the debtor or a trustee decides they're going to dishonor the license. They're going to what we call reject the license. And this is one of those somewhat rare instances in the bankruptcy code where the counterparty, the non-debtor, actually gets to continue with some rights, notwithstanding the rejection and repudiation of the license agreement. And so the statute specifically provides that the licensee can, if the debtor's going to dishonor the license, the licensee can agree that the license is terminated and assert a breach of contract claim against the bankruptcy estate of the debtor, or the licensee can continue with the license, notwithstanding the rejection and repudiation for the term of the license. However, the licensee will not be able to force the debtor to continue to specifically perform, meaning to do the upgrades and such. And so that's why it's important, and I do this with my intellectual property colleagues, it's important to get source code for the intellectual property up front in the event of a bankruptcy, because bankruptcy will honor the source code agreement and allow the licensee to continue to do whatever is necessary, hire a third party to come in and take care of the upgrades on the license going forward. Those are the general rules on both sides of it, whether the debtor is a licensee or a licensor, and I look forward to questions on it later on. Back to you, Andres.
Thanks, Patrick. That's really interesting, and I think it goes well beyond the licensing issue, right? I think you touch upon a couple of things that for insolvency practitioners around the room need also to bear in mind. One of them is the clash or possible clash between the bankruptcy law and other statutes, right? Which I'm sure that in Saudi Arabia must have its own solution. And the other one is the possibility, which I believe it's also given by Saudi Arabia's law, the possibility for the insolvency practitioner to reject certain contracts after the commencement of the process, right? It's something that I think it's one of the key provisions in many jurisdictions that to reject the onerous contracts for the state. So I just wanted to emphasize that those things may have different solutions in Saudi Arabia, but it's just the concept of that possibility happening is something really, really important. So thanks, Patrick, for bringing that up. I would like to hear now from the UK. I think Paul, my question is, do you have a similar process that allows you as an insolvency practitioner to sell intangibles, and how that functions in the UK, how that works? If you can give some precisions around that.
Sure, thanks, Andres. So this is a complex and wide-ranging discussion. I mean, the first thing I'd say is that the situation in the UK is not that different from the situation in the USA as described by Patrick, broadly speaking. I think it's an essential point that Patrick makes when it comes to the sort of intellectual property that we will think of first and foremost: brands, trademarks, copyright, patent. It depends on whether you're the actual owner of that intellectual property, right? So is the debtor company the owner, or is it, licensing it from somebody else who owns that asset? And can that licensor stop the insolvency practitioner from transferring the IP? Is it just a contractual breach which gives rise to nothing more than an unsecured claim against the estate? Or is there some further consequence? Now, I'll give you an example which I came up against very recently, where I was the administrator, so a company subject to a formal administration insolvency process in the UK that had produced some food products for one of the large supermarket groups, and had done so under some branding produced by the debtor company for the benefit of the supermarket group. But actually, the supermarket group didn't own the copyrights to the branding and didn't own the design rights. But when I, as the insolvency practitioner, considered selling these products to the open market rather than selling them to the supermarket, who were being quite difficult about acquiring them, my legal advice was that I, as the insolvency practitioner, could actually be held responsible for breaching certain intellectual property rights because the name of the supermarket appeared on the labels. So it wasn't the debtor company that was going to breach the contractual right, giving rise to an unsecured claim. It was actually me as the insolvency practitioner, because I was the one who was conducting the sale. So that was quite an interesting specific example. Let's also think about things like, we wouldn't necessarily think of something like a contract that the debtor company has with a utility company or with an IT vendor. You wouldn't necessarily think about that as an intellectual property right, but in some respects it is. It's basically just, this contract gives me the right to acquire a particular product from you at a particular price. And what we do have in the UK is legislation that, within the context of an insolvency process, the administration process, I, the administrator, could compel that supplier to honor that contract, to honor the terms, and to continue supplying me. It's not intellectual property necessarily in the way that we sort of truly understand it, but it's a non-tangible right, that contract, and I can compel them to actually transfer that if it's for the benefit of the going concern sale of the business. Something else I'd like to mention is, and Patrick touched on this, things like websites. If I, as the debtor company, have produced my website, I own the copyright to that website. That's absolutely fine, and my ability to transfer that copyright is unquestionable. However, who is actually hosting the website? That becomes a problem. If you find out your website is being hosted by a third party and they are the registrant of your URL, not the debtor company, and you happen to owe that particular IT company and that registration company a lot of money, they can hold you to ransom. So it doesn't matter if you own the copyright, you can't actually transfer it because you can't transfer the URL associated with it. Beyond that, the transfer of intellectual property, and I sell intellectual property a lot on a going concern basis or otherwise, there are just administrative procedures to observe, making sure that you transfer. You know, we have a trademark registry, there are forms to fill out, you have to sort of do it in a particular way. But it's the sort of the detail behind it that can really sort of catch you out, as it were.
Thanks, Paul. That's excellent. It's incredible how many nuances one has to take into account with intangibles and with intellectual property. Let me pass it on to you, Mark. At some point, you mentioned that the origin of the financial distress, whether the financial distress is operational or if it's financial, it can be important to take into account at the time of selling assets as well. So I would like you to elaborate a little bit more about this. And also, if you can talk a little bit about the role of having some liquidity at this stage, could be via deep financing or somehow else. So if you can expand on those points, thank you.
So Andres, let me add to the operational and also what I'll call financial causes. There's also a broader kind of macroeconomic cause. I actually run our aviation business worldwide, and as everybody knows, there's these broader macroeconomic issues, whether it's COVID. Candidly, we did a lot of work with Northern European airlines at the time of the Ukraine-Russia war, because you couldn't have those airlines fly east over Ukraine or Russia. They had to fly around. As a result of flying around, given the cost of fuel, that caused a whole lot of financial distress for airlines in Northern Europe, given their route structure. So there's a whole macro overlay to financial distress. As you get into specifics, operational causes, bad contracts, obsolete technology. I have a perfect example of obsolete technology I'll go through in a second. Fraud, competitive environment, all add to what I'll call the income statement type problems or the operational problems in financial distress. I'm just finishing up a 363 sale of a company who pre-COVID used to provide the technology to go these types of calls from conference room to conference room pre-COVID. So you would go from Riyadh to London, London to New York. You know, in COVID, nobody would go into work in COVID. So as a result, nobody has this conference calling ability. That's when Zoom comes in and Teams come in. And as a result, that technology became more and more obsolete. There were pieces of that technology people wanted, but as a result of kind of COVID, it became obsolete and you had to sell off the business. That's an example of an operational issue with obsolete technology. I think financial causes, that one's fairly easy. Look, at the end of the day, businesses were financing themselves not less than 24 months ago with 2% interest rates, at least here in the US. It's now 7.5% interest rates. And so that 550 basis points alone on the balance sheet and that cost of debt is causing a whole host of issues from a financial perspective. So it had a decent business when interest rates were 2%. It's not so good when interest rates are 7.5% or 8%, and they have to go through that environment. So that alone, the interest rate environment alone on the balance sheet side causes some issues. When we look at bankruptcies in the US, we have something called debtor in possession financing. That allows third parties to basically come into a bankruptcy situation and finance the bankruptcy, get a priority lien on all of the assets, assuming people are in agreement. If you have all unsecured debt, it's easy to get a priority lien that helps finance the business while you go to sell it and maximize value. If there's not enough liquidity, as I think Paul was talking about, we do have a provision within the US code that allows money to come into a bankruptcy situation to finance that going concern sale throughout the process. It gives them a priority lien, but it does help maximize value because it helps elongate the process if necessary to go ahead and sell the business as a going concern.
Thanks, Mark. That was very useful, and indeed, deep financing is one of the critical issues, and probably deserves a whole panel by itself. And so, okay, let's move to the last question from my side, and then we'll open it up. I'm trying to summarize the questions that we're getting, and I'm sure that they will keep you entertained for all the rest of the panel. But before I do that, Duncan, let me close this first part with you. You mentioned the different sale methods or techniques. I wonder, I mean, in the UK, so just to sell assets, do you always have to go through a public auction? Are private sale methods contemplated? How do auctions work? Can you do a live auction, online auction, or is it still the more traditional mechanism with a hammer? So I wonder if you can elaborate a little bit on sale methods in the UK, just to give a comparative perspective. Thank you, Duncan.
Yeah, sure. And just the UK, but I think it speaks for, in my experience, North America as well. There are typically, if we're liquidating, there is a need to sell within a given time frame the assets. And as I mentioned earlier, we've reported on the likely value, the outcome of that process. And in the valuation process, we also, as I mentioned, provide our advice regarding that. But when it comes to actually method of sale, how are you going to do it? I mean, we're not compelled. We don't have to put everything to auction. Some jurisdictions you do, I know, across the world, but essentially in the UK, we don't have that restriction. We can market the assets for sale. We typically use three methods, really, and I'll lump the auctions together. So the auction is, I think people will understand, in it's one of the oldest professions in the world, where you stand with a hammer, someone calls the numbers, and as the hammer comes down, it forms a binding contract of sale. The online auction is essentially the same. It's backed by the same laws at the time it closes. It's all online. It's an event that is obviously on the web. As the time clock runs down and it finishes, then it again forms that binding contract. So it is an auction. One is live with an auctioneer, and people either physically attend or can bid over the web. And the timed online auction is a pure virtual event. And both of them are as effective as the other. Over the last 20 years of online auctions, there's been a lot of studies, and it's not been proven either way that one method is better than the other. And in fact, the data I've seen from the largest auctioneer in the world says it doesn't matter which way you do it. If it's auctioned, it's auctioned. The key to running a good auction is marketing and having people coming and having people buyers, right? An auction with one person is not an auction. An auction with 1,000 people is a pretty, as long as it's marketed effectively. So the auction is probably the most recognised and the most used method in the UK market for liquidating tangible assets. The other way, and again we come back to this production line issue. This production line that may make fiberboard, it may make boards for use in the building industry. Well, that doesn't break down. It does what it does, and it might be 30 meters long. It might be 50 meters long. And it's probably got a more specialized market. And I think you've got to look at the liquidity of the asset to determine which is the best method. And a highly liquid asset like a JCB, a construction digger, which has millions worldwide, is traded assets, a liquid asset, then you can pretty much assume if you put it to market through an auction, well marketed, you will get the market value for that asset. With a production line, you probably need to do the marketing and actually get people to come and see you. Users, you won't find people who will buy it on spec and put it in their factory just in case they need it. The values are too high. So you'd look for more a private treaty or a negotiated sale method to sell that asset. So it's really about the liquidity of the asset, and that's where, as a third party, the expertise, the advice will come. I think it's also worth pointing out, and it's particular to the UK market, but should be considered, that when you're selling these assets, they need to be sold as seen. There's no warranty either implied or given when you're selling these assets in a liquidation. And you've got to be very careful in the UK that you don't sell it to a consumer. So it has to be business to business. And that is really crucial to the UK market, because if you start selling assets to a consumer, then other laws that we have kick in, and then you can find yourself and your client can find themselves in trouble for selling assets to consumers, because they will have a different, there's a whole different raft of regulation that protects the consumer, whether they're buying it at an auction or not. So that needs to be done. So you need to make sure you've got, the right terms and conditions, the right method of sale, be it private treaty, negotiated sale, auction, and backed up by a proper marketing and a proper period. You've got to have time to do this, and the value is time is a value of the value. So it really is about what is the asset, how much time have you got, and that will determine the best method of sale for you.
Excellent, Duncan. Thank you so much. That brings us back to the traditional mechanism of auction as one of the desired alternatives. Let's move to the questions and answers. I've been trying to translate them, and thanks, Abdullah, for also helping with this mechanism, and thanks to all of you for asking so many good questions. Let me begin, and I'm going to throw some of the questions out there, and I'll let the panel respond. I was trying to cluster them in topics, and one one of the topics that has been asked so far, and I would like to hear both from the UK and the US views, is on the trustee compensation, which is a topic that we have not directly touched upon in this panel, but there are questions. First of all, is a trustee or the insolvency practitioner entitled to a commission for selling an asset? I guess the same could be applied for selling a business. That comes from an anonymous attendee. But then Khalid Muhdar also asked a question about trustee compensation, which is how is the liquidator's fee determined and how fast on average? So those questions on trustee compensation, I would like to hear the panel, whoever wants to take this first. So any volunteer?
Yeah, I'm happy to answer that from the UK perspective. So let me just set the background. I mean, generally speaking, in the UK, formal insolvency processes, as will be the case in other jurisdictions, the compensation of the insolvency practitioner is subject to a very strict regulatory framework. And depending upon the nature of the situation, different classes of creditor will ultimately get to approve the insolvency practitioner's fees. And we have to be very open and transparent. First of all, about the basis upon which we record the value of the work that we're doing. And secondly, the basis upon which we then charge for that. So there are two distinctions there. As a default position, any work that I do as an insolvency practitioner, including any work I do realizing the assets, the value of that work will be measured with reference to my hourly charge out rates. And obviously each member of my team, depending on their grade, their seniority, their skills, their length of experience, will have a different charge out rate. We're all very familiar with that. So the starting point is that we say, well, when we're doing asset realizations, we will charge on a time cost basis, and that will be the cost of realizing the asset. However, sometimes there are assets which are incredibly difficult to realize, and they will require me to speculate on a contingent basis the cost of my time, and there'll be uncertainty as to the outcome. And in those particular situations, I am entitled to say to the creditors, well, actually, if I'm going to speculate my time here, and I'm talking now about, I say, a different class of, this is just to illustrate the point. It's not about tangible assets, but say I have to enter into some litigation in order to try and issue a claim, in order to try and enable me to sell a particular asset. There is no prospect of certainty, and I'm doing this for the benefit of the creditors, and I'm speculating my time costs, and I might get nothing. So as compensation for the risk of me getting paid nothing despite putting a lot of time on the clock, I'm entitled to ask for an uplift and say to the creditors, well, actually, if I do manage to recover this asset, if I do manage to go through the process, if I manage to defeat competing claims to the asset from other parties, then I should be entitled not just to my usual hourly charge out rate, but actually an additional. Now, what I might say to them is I will charge a percentage of the value of the asset realized, and the more value I get for it, the higher or the percentage might change, and I can do it on a ratchet basis. So we can be quite flexible, but the important thing is absolute transparency and to make sure that the creditors have a degree of control so that they're not seen to be, the situation is seen to be an honest and a straightforward one.
Thanks, Paul. That's very clear.
Hey, Andres, just the time management. It's the same in the United States. Right. Basically the same. Exception, Chapter 7 liquidation, Chapter 7 trustee has a sliding scale, higher percentage for lower sale, lower percentage for higher sale. We have all the flexibility, have all the transparency, same thing. That'll help you get onto another topic.
That was super efficient, because we keep on receiving questions. What I like about moderating panels with this group of trustees is that they are not particularly shy. So they ask already 16 questions. So I will beg all of you in the panel to try to keep answers short, which you're doing, by the way. So I really appreciate it. Good. Question on timing of sales. Someone asked about whether to deliver a better outcome if the business owner, I guess in this case, the insolvency practitioner too, could sell the assets during the period of filing for bankruptcy. And the reason is basically that the bankruptcy approval sometimes takes time and assets, maintaining cost and money and risk. I guess here we're entering a little bit into possible clawback auctions as well, if the business owner sells right before filing. So I don't know if anybody wants to touch upon that timing of sales and possibility to sell. What's the right period and the right approvals? If anybody can touch upon that.
Let me take a quick stab at that.
Thanks, Mark.
So I think the timing of sales, when I look at this, is if there's significant pre-petition, pre-filing marketing, then you can shorten the time in bankruptcy and sale, because you've already been out to the market. They know it's for sale. It can be quick. If there hasn't been any pre-petition marketing, typically that elongates the period in bankruptcy, because you've got to go through a full marketing and educate the market. So in my mind, it really depends on if there's been any pre-petition marketing of the assets.
Excellent. Thank you, Mark. That was also quite efficient.
Maybe if I could just. Sorry,
please,
can I
Paul, go ahead.
just add one thing to that?
Yeah.
This question of, can you actually sell the assets prior to the petition? In the UK, your assets can be sold prior to the instigation of the formal insolvency process, but it is incredibly important that the directors of the company conducting that sale do so for arm's length value, without it being considered an undervalue. If they do it and they do it under advice in accordance with somebody like Duncan, then they won't have an issue. If they sell the assets at an undervalue to their best friend, they've got a big problem on their hands.
Excellent. That's a very, very good point, Paul. I think the issue of arm's length sales, and particularly of making sure that there is no undervalued transactions, because that can trigger a lot of other provisions in the law. Even I do remember vividly that the Saudi Arabia insolvency law has a provision on what we could call clawback avoidance actions or clawback actions, etc., to basically annul certain transactions made before the filing, undervalue or preferential, etc. Right? So that can be triggered with this type of sales before filing. It's something important for the practitioners. Also, that at some point they may have to review these transactions as well. Let's move on to a question that we have on the outcome of the process. Please go ahead. Yeah.
I was just to punctuate the point you just made, Andres. Paul was talking about the directors, the seller side having a problem. Andres, your point is excellent, which is the buyer is going to have a problem if they underpay. The buyer always wants to pay less than fair value. A buyer wants to overpay, right? So the problem, I will advise a client who really is salivating to buy an asset on the cheap prior to the bankruptcy. That's fine. You can go, but recognize if they wind up in bankruptcy, somebody could be coming after you, and that's a reason to actually do it through a bankruptcy, is to get the order I talked about in stage one of this.
Excellent clarification. Thanks, Patrick. Yes, indeed. I was thinking about the potential issues that the buyer may face if buying one of these. Okay, so moving on to another question. There's a question on valuation, I guess, Duncan, that goes mostly for you. The question is, there are two questions on valuation, which I'll consolidate. First of all, the first question is by Ghassan, who asks, is it best practice for assets to be evaluated by certified appraiser to determine the fair price for them before starting the sale? And there is another question on valuation. Apologies, I'm scrolling down. Okay, sorry. No, the other question is in auction, which also is for you, Duncan. Would the auction option be the best in terms of selling the assets with the highest value given the short period? Is that a way to maximize value of assets other than auctions? So that's the other question, basically about alternatives to auctions. Duncan, please go ahead.
Okay, so the first one around certified appraiser, I think it was, whereas in the UK, yes, you have to use a company that is registered with the RICS, which is the standard we have. We also operate under American Society of Appraisers, but the RICS, and maintaining, importantly enough, professional indemnity insurance, essentially. So when we're giving our values, they can be relied on by a third party, and there is recourse to the valuer if they're very wrong. So yes, you use a certified appraiser. Not common across Europe, but certainly in the UK. Regarding the second question, I think, which was about the auction and whether it's, I can't quite remember, Andres, is it the best in a short time frame? Was that the question?
And the question was, what happens in cases of where the time frame to sell assets is short? I guess it's ending the timeline to sell the assets.
Yeah.
Are there any alternatives other than auctions to maximize value?
No, I mean, if it's a short time frame, it's essentially, I hate the word, but it's used often to me as a fire sale, which it needs to be sold by a certain time, and you haven't got enough time to do a proper marketing campaign. You have to go to auction with it. Unfortunately, if that's what's driving the process, that's what's driving the process. Is that the best method? If it's a reputable auctioneer you're using, who has a ready buyer database, then yes, I mean there's nothing else you can do. I mean, you can, short of just walking around with a board on you saying equipment for sale, auction is the trusted method. It's just going to affect the pricing, right? If it's a short notice, then it's going to affect the pricing. I think there's always that question around, are you getting market value? Well, and if you go to auction, the thing is, it's transparent, right? And in any of these processes, what you want to be able to do is sit back with the creditors or with your clients at the end of the day and say, I've done the best I can, and this is what I've done. And if you've gone to auction, then there's a lot of traceability and auditability in that process. How many people came to the sale? How many people registered? What were the bids? And if that's the transacted price at the end of the day, I think the important thing is just to make sure that it's fully open and transparent of what you've done. If your hand is forced and you have to go quickly, just we make sure that it's done in a very, very transparent way.
Excellent, Duncan. Thanks so much. That was very clear and to the point. Let's move on to the next question, which I have here. This one is particularly for Patrick. The question says, you pointed out an important point, which is creditors' resistance to sale decisions and controlling them. What are the best ways to win the judge's direction against creditors' resistance, as the majority often controls the decision?
Well, I think there have been a couple of them mentioned so far. One by Mark, which is, plan ahead, and hopefully you've done your marketing, your diligence before you go into bankruptcy, and you can come with a story to tell the judge about what you've done to expose whatever it is you're trying to sell to the marketplace. Because typically, one of the ways creditors committee try to trip up the process, it's really more extortion than anything else, is to try to elongate it. And the other is, and you'll hear the judges say it as much as the debtors, which is, put your money where your mouth is, right? If you think that the assets are worth more than the debtor and its professionals like Paul and Mark are running these sale process, if you think the assets are tremendously worth more, then tell us why, and where, who's going to bid? Are you going to bid on it? And creditors tend to get quiet when judges push back on that, and you've got really good professionals like these gentlemen, all three of them, pushing a proper asset sale and business sale forward. So I think it's preparation, and asking what are the alternatives.
Thanks, Patrick. That's very clear. Mark, I think we have a specific question for you. I'm scrolling it up because questions keep on coming even now. So they are moving. They're a moving target. Okay, I'm sorry, but the question that I had just went away. Okay, sorry. Let me go to Duncan once again. Is evaluation of asset mandatory?
Yes. Well, I mean, I'll probably leave this to Paul to answer. I mean, I'm only his humble client, but yes, as far as I understand it in the UK, a third-party valuation. But I think there are some kinks to that, Paul. I think it's not absolutely 100%, is it?
Yeah, I mean, there would be very few circumstances where you would not seek to have a valuation. It might be that the asset is incredibly difficult to value in the time available. And then what we would do would be to ask somebody like Duncan. We would write and say, look, Duncan, we've had a series of bids for this asset. We haven't had time to sort of get a formal valuation. Can you write us a letter of recommendation and tell us which of these bids we should accept? And Mark made the point that sometimes it's not necessarily the headline price which is the only decision-making factor when you're accepting a bid. You know, you've got to look at the credibility of the purchaser, whether actually they have the money to acquire the asset, the terms upon which they're seeking to acquire the asset. Somebody offering, you know, $10 million, but they're going to pay you over the course of 5 years is clearly not attractive if you've got somebody else offering you $5 million cash today. So where we don't have a valuation, in those rare circumstances, we would seek a letter of recommendation from the agent, because it's all about transparency to the creditors. But generally speaking, in the UK legislation, particularly when you're selling as an administrator, which is one of our rescue procedures, you are actually obliged to go and get a valuation of the assets.
Not so in the United States. In a sale process, you would not typically see an appraisal. The only appraisals come up where there's litigation. So cash collateral dispute, potentially you may have an appraisal valuation. Dip financing, maybe if there's priming liens and the like, you might have some appraisal disputes, and a confirmation hearing where you're fighting about whether the secured creditor is getting what it's entitled to, or somebody in a capital stack is getting to whether they're getting what they're entitled to. But in the context of a sale process, a new appraisal for purposes of justifying the sale is rare.
Yeah, and I would add to that, in running that process, the last thing I would want to do is put a valuation on a going concern at the beginning of the process, only to be wrong at the end. And so we are very reluctant to put valuation numbers on a piece of paper at the beginning, as opposed to, Patrick says, at the end at a confirmation hearing.
Excellent. That was such an interesting question about the mandatory valuation or not. It's fantastic to hear these different approaches. I'll take as many questions as I can. We have only 8 minutes remaining, and we have 15 open questions, which keep on coming, right? So which I think we will manage to try to answer some of them after the panel finishes, perhaps in a written form or somehow else. So let me pick and choose some of them. I do apologize to those of you who ask questions and will not go answer today, but it's just impossible to do it with the time. Rashid is asking about whether it's possible to invest assets instead of liquidating them. I would like to hear very quickly the views from the US and the UK on this.
Can you quickly repeat the question?
Can you ask for the question again? I'm sorry, I missed it.
Yes, of course. Rashid is asking, is it possible to invest assets instead of liquidating them? For example, in existing companies, factories or real estate that can be invested or developed, instead of just going through a liquidation sale?
Well, I think if you look in the US, there are certain, outside of a sale process, there's a regular Chapter 11 process where the existing creditors can do a whole host of things, including owning the assets and investing in those assets going forward. So I guess it just depends on the type of Chapter 11 process you're running here in the US, whether you're basically an investor or a seller.
Yeah, if I understand the question, I think it would be something that's very rare. You're talking about a cash-strapped enterprise, right, who's borrowing money from somebody else at a higher than sort of probably market rate of interest, and the lender itself can, DIP lender itself or the secured creditor can go out and invest its own money. It doesn't need the in any way it wants to. It doesn't need the debtor to do it. The debtor's cash strapped. It's underwater. It's over leveraged. Going out and investing in something is not something you would typically see because it doesn't have the resources.
What I'd add to that, the circumstances under which, you know, and maybe this answers the question unless I've misunderstood it. When I take control of, say, a part-built real estate development, in those situations, obviously, I can look to see if creditors or the secured lenders want to effectively invest in that asset so that I can complete the development in order to sell it for greater value. And the other area where I might ask creditors to invest in an asset would be invest in a litigation asset. So where I potentially have a claim to take against a third party, and the successful resolution of that claim will deliver value to creditors. I might say to the creditors, well, do you want to invest in actually moving this litigation forward? Or it might be, do you want to invest in doing some asset tracing? So, you know, we think there are some assets in a different jurisdiction we don't know. We're going to have to use the sort of services of my fraud and investigation team. Do you want to investigate? Do you want to invest in that? We will investigate, and then there might be an outcome for you on the back of that.
Right. Thank you so much. Someone is asking about the sale of receivables. If there are any techniques to maximize value, or what are the global experiences in selling receivables? Is that a typical case? Is that something that you faced, any of you?
Sure, I have. There's complications with selling receivables in bankruptcy because typically when you go to collect, the counterparty might have set off rights. So they may have a $10 receivable, but if you're supposed to ship them product for the next 6 years and that product is at risk, they can make an argument that they need to set off against that $10 receivable. So certainly there's an ability to sell those receivables, but it's more complicated than just selling the face amount of the receivables given future performance issues, the way I would look at it.
Again, in the interest of moving forward quickly, same in the UK. And the other thing I'd say about receivables is the minute you're in an insolvency process, the counterparty will find 100 different reasons not to pay you.
That's excellent. Thank you. That was actually very enlightening. Thanks. Perhaps I'll take the last one from Ehsan. You mentioned some of the key success factors on going concern sales, and I really like this question. How would the stakeholders control or monitor the costs associated with the sale process itself? This probably deserves a longer answer, but I'll ask the panel to summarize this last one. Thanks.
I think in the U.S. it's a real honestly, it's a challenge. On the one hand, because no one knows what's going to happen up front, but Paul's description of it in the UK is the same in the US. Transparency, approval of the brokerage agreement, the sale agreement, all of the fees, all that stuff should, other than sort of the meter, meaning my hourly rate, somebody else's hourly rate, and how much time is spent. The rate will be pre-approved by the judge, but we don't know how many hours it's going to take to get to the end game. We don't know what the problems are going to be, but transparency and arrangements are approved up front with total transparency, and the creditors have an opportunity to complain about it up front.
Again, same in the UK.
Brilliant. That opens up the possibility of one final question then. I'm sorry. So someone is asking about the possibility of hiring related parties to do some work for the bankruptcy when it's easier and faster. I mean, what would be a good practice not to be under conflict of interest risk? My answer would be don't hire related parties. But what are the rules on this in the UK and the US?
Should I go with the UK? Oh, sorry, Mark. You go ahead.
Go ahead.
Okay, well, look, just very quickly in the UK, yes, we can get related parties involved in assisting in the sale process. And there might be some really good reasons to do that because of their sort of knowledge, their relationships, their connections. But coming back to what Patrick said, and it's a running theme here, transparency, openness, making sure that absolutely has to be disclosed to the creditors to make sure there's no actual or perceived conflict of interest that is going to disrupt the process.
That's pretty easy. Same here. It's all about disclosure.
Fabulous. Okay, well, huge thanks for that last ping pong of questions and answers. Thanks to all of you for keeping them so short. Abdullah, let me pass it on to you.
Yeah, thank you so much. On behalf of the Bankruptcy Commission and all the attendees, I would like to express my sincere thanks to you for your invaluable contribution to today's online workshop. Your expertise, insights, and willingness to share your knowledge have been truly inspiring. Thank you so much. We really appreciate your time. I'd like also to express my thanks to our trustees and experts for attending today's event and for their engagement. Special thanks to our partners again in Seoul, CLDB, and the World Bank. To finish this panel, thank you and have a good day to our panelists, and good night here in Saudi Arabia. And I hope to see you soon in future events. Thank you so much for your participation.